Welcome, everyone. I'm going to just give it a couple of minutes or a couple of seconds to let everyone join. Thank you for joining us today. So people are still trickling in from the waiting room, but I want to be respectful of everyone's time, and I know we have a lot to get to today, so let's go ahead and get started. Welcome, everyone, and thank you so much for joining us. My name is Mosa Manesh, and I am a professor and the Associate Dean for Faculty Research and Programs at the University of Oregon School of Law. And it's my pleasure to welcome you to today's Oregon Law Perspectives webinar. I'd also like to extend a special welcome to our Summer Sports Law Institute students who are joining us from Classroom 141 in the Knight Law Center in Eugene. The Oregon Law Perspectives series brings the work and expertise of our esteemed faculty to our colleagues, our students, our alumni, and to the broader public. Today's session is the first of our summer webinar series. We are joined by three of my wonderful Oregon Law colleagues to discuss different facets of name, image, and likeness in college sports. Let me introduce them briefly in the order that they will present. First is Professor David Weber, who is an incoming associate professor at Oregon Law. He comes to us after 17 years on the Creighton University School of Law faculty, where he founded and was the faculty moderator of the sports law concentration at that law school. He previously was an attorney at the multinational law firm Friedrichsen and Byron, PA. Next will be Professor Brian Derringer, who is an associate clinical professor of law and the director of Oregon Law's Summer Sports Law Institute. Professor Derringer joined Oregon Law's faculty in 2023 after serving in the University of Oregon's General Counsel Office as Associate General Counsel. He was also, before that, an adjunct professor at the law school. Previously, he worked for 10 years in the federal courts, primarily as a trial attorney in the Civil Division of the United States Department of Justice in Washington. Finally, we have Professor Lori Hauber, who is an associate clinical professor and the director of experiential education at Oregon Law, leading the law school's clinical and externship programs. Prior to joining Oregon Law, Professor Hauber founded and directed economic development programs, including the Community Economic Development Program at Legal Services of Eastern Missouri and the Community and Economic Development Clinic at Vanderbilt Law School, where she was part of the law faculty. For more on Professors Weber, Derringer, and Hauber, please visit the Oregon Law Perspectives website. Our plan for today's webinar is as follows. Our presenters will each speak for approximately 15 minutes, and then we'll save time at the end for audience Q&A. If you have a question, please feel free to use the Q&A feature on the bottom of your Zoom bar. Only the panelists and I will be able to see your questions, and they can be anonymous if you so choose. We will gather your questions and attempt to address as many as possible at the end of today's presentations. For those of you who are seeking CLE credit, you will receive an email after today's webinar requesting your bar number so that we can report your attendance to the Oregon State Bar. With that, please join me in welcoming our three speakers, and we'll start with Professor Weber.
Thank you, Mohsen. Welcome, everybody. Thank you for spending part of your Friday afternoon with us. I am going to talk primarily about the recent House settlement and the ongoing evolution of college sports. It feels like we have been in 10 years of a whirlwind, and I think we're probably only about halfway done with that whirlwind. I think we're going to see a lot more going forward in the next 5 to 10 years with a number of different issues. But my focus today will primarily be this House settlement. Undoubtedly, you've heard about it in the news. It has been the epicenter of college sports for at least the last 12 months, and it really gets into the nitty-gritty of changing college athletics from a play for the name on the front of your shirt to maybe we can get paid, even though direct pay for play is still prohibited. So the timeline for this litigation has been the last 2 years or so, but we started to see some significant movement last summer. And then we saw the parties come to a preliminary agreement last fall. That was finally approved earlier this spring, and it was effective as of June 6th this year. So what does that mean? That means that now going forward, as of July 1, universities will be able to directly compensate their athletes Again, not for playing specifically, but for their name, image, and likeness rights. So, a couple of major components with this settlement agreement, and I will break it into two large buckets in just a second. But the first one is going to be NIL back pay. That is going to cover NIL related payments for those athletes who would have been able to make money from NIL, but at the time that they were in college, it wasn't permitted. And so that is the roughly $2.8 billion bucket that you've heard about. Many of the athletes in that class, if not all of them who have not opted out, have already received their notices saying that they're eligible for these types of payments, though that is potentially being upheld for now because there has been an appeal to the House settlement, and we'll talk about that in a little bit as well. So that was the first big chunk of the House settlement, that NIL back pay. The second big chunk is the prospective revenue sharing moving forward. So I have them listed there as change 2 and change 3. This is what you're hearing about now when schools are trying to figure out how to allocate a budget of anywhere between 20.5 million and 22 million per year in the near term, up to 32.5 million or so by 10 years from now. And so here we see schools trying to allocate these funds in a way that will work for them across all sports. So the bulk of the funding will most likely go to college football players, probably 70 to 75%. The next big chunk, around 15 to 20%, will go to college men's and women's basketball players, leaving just whatever is left for all the remaining sports. And that is certainly one of the ongoing tensions with this settlement agreement. It seems like the rich get richer, and then the poor, well, they don't really advance as well. And as part of this settlement agreement, we have new enforcement mechanisms and structures put in place. So we have this new entity called the College Sports Commission. This is ostensibly taking the role of the NCAA insofar as it relates to the House settlement agreement. So things like how much can universities pay, that salary cap, things like third-party enforcement. So we hear about these collective deals, which we'll talk about more in a little bit as well, trying to enforce those rules in a way that is going to have teeth, and it's such that the NCAA never had. So we have a couple of things that go along with this. One is the CAPS, that's the college athlete payment system. This is what universities are going to use to figure out and make sure that they're managing their own rosters and budget. And then we have this other entity called NIL Go. NIL Go is going to be administered by Deloitte, and this is going to be monitoring third-party deals with related entities. So all of those deals entered into by collectives, these are the ones that you heard of that are in the millions of dollars, they're going to go through this clearinghouse and they will get either approved or disapproved or ask for some more information. And so that's really going to be one of the unique aspects moving forward. So before we get into the nitty-gritty of the House settlement, a couple of other things I wanted to just briefly mention. On that back pay element of that 2.8 billion in direct damages, you can see on the screen how that's going to be paid. And you're going to see 41% is coming from the NCAA's cash reserves, 24% from what were historically the power conference schools, and then roughly 35% from all of these other schools. And so to the extent that you've heard of these smaller schools, the group of 5, group of 10, the FCS schools complaining about the House settlement, it's because they're actually funding some of this NIL back pay, even though their athletes would not have earned a penny from that type of NIL agreement. So the schooling that you've heard has definitely been behind that. They were unsuccessful in trying to get that changed. And then on the right, that annual direct compensation, that's going to be this prospective going forward starting July 1, universities paying directly to their athletes. So where I want to spend the bulk of my time this afternoon is on a couple of these key provisions of the settlement agreement. So we already talked one about the fact that universities can directly pay their athletes. It's new. It's still sort of a wink, wink, nod, nod, because they're still saying it's not pay for play, even though I think we're going to see that NIL value, as universities determine it, is going to strongly correlate with athletic ability, more so than perhaps sheer value that might be related to the athlete's social media brand. But a couple of the other big issues that go along with this settlement agreement. Number two, there are going to be roster limits now. Previously, the NCAA had scholarship limits, and these were divided up by sport. And you had some interesting allocations with decimal points, and coaches were tasked with trying to divide up those scholarships. The NCAA and the House settlement has gotten rid of that, and we're going to go toward just pure roster limitations. And this was actually one of the last sticking points for this settlement agreement to be approved, because Judge Wilkin, who was the judge overseeing the litigation, was really concerned about athletes who were going to be worse off as a result of this settlement agreement. And for a lot of these, you can think of the classic quintessential walk-on player. This individual who had a roster spot but wasn't going to be receiving any scholarship, and the universities could have dozens of these athletes on the field. Ultimately, the parties came up with a solution that is a grandfathering of sorts. What that means is college athletes who were going to lose spots are grandfathered in, but they weren't guaranteed a spot at their previous university. So if they do decide to transfer, if they do move on, those spots that they're going to occupy will not count against the roster limitations for the period of their remaining eligibility. After that, after they're through the window, then all schools will still have the exact same number of roster spots, but for a short period of time, that eligibility issue, that roster spot issue will be present. 3 and 4 are probably the biggest areas of difference from where we were to where we're going now. And so the CSC, the College Sports Commission, is this new entity, and the CSC was created in part because the NCAA was, I think, tired of being sued all the time and always losing in antitrust grounds. And the CSC doesn't have $1 billion annual income from March Madness. And so if we're thinking about entities like bankruptcy remote vehicles, this is a great special purpose vehicle trying to limit some of that liability moving forward. So the CSC is going to take on the role of enforcer for the new House settlement agreement. And they partner with Deloitte, which is going to go ahead and start to look at all of these NIL contracts. From the outset, all contracts $600 or more will need to be submitted and disclosed. Now, for related entities, there are additional hurdles to get them approved. The athlete, once they submit it, Deloitte will review them on a number of factors. They're going to look at what is the relationship between the payer and the payee. Is this a person who is trying to get primarily a sporting or competitive benefit for a particular university? Will the athlete be endorsing certain goods or services? Is it going to be more of a bona fide NIL activity? And then also, what is the geographic locale? Because some markets are going to be worth more than others, and they're going to put that into their algorithm, and that will sort of spit out a yes, this is a valid NIL deal or not. When Deloitte presented on this back in April, they said that their belief was that 70% of existing collective deals would not have passed muster under their new approach. And in fact, only 90% of unrelated entity deals, deals with public companies, would have passed muster. So they're saying that even 10% of those deals would not pass their new system. So what does that mean? What happens if NIL Go comes back and says, your deal doesn't pass what we're looking for? Well, there are a couple of options. The athlete and the collective or the entity can go and renegotiate and resubmit it, which is an opportunity. They can simply rescind it altogether, or the athlete can say, I'm going to proceed with, or they can appeal it to a neutral arbiter. But once you get into arbitration, it's going to be an interesting system that's going to be, of course, out of the public eye, probably not going to be appealable on many grounds, if any. And some of these athletes have opted out of the House settlement. Are they going to be bound by that arbitration system as well? That's another unknown. So you have these interesting issues. And then lastly, the athlete can decide to say, I'm just going to go ahead and see what they do to me. The rules in terms of what the punishments are going to be aren't yet clearly established. But what's been talked about are significant punishments, somewhat similar to what the NCAA used to have for some of these Title I and Title II, or Level 1 and Level 2 violations. And that was going to be things like loss of eligibility, fines for the university, potential loss of transfer rights for the university, potential suspensions of university administrators if they're violating these deals. So they're trying to put more teeth into this new entity, but I think there's still a lot of suspicion as to whether or not this is going to work. What is the mechanism that we're going to be able to rely upon to force athletes and these unrelated third parties to come forward and disclose? And I think there is some strong suspicion still there going on. And there have also already been creative attempts to circumvent these new rules. And so one of the creative attempts is, well, if we're going to get these deals looked at more closely for related entities, what if the collectives just, in essence, launder their money by giving it to bona fide businesses and say, we will give you $1 million for your marketing fund. Now go out and sign this athlete. And so now you have this local dairy company who is spending $1 million to promote their milk company. and they're unrelated. And so I think from the outset, what we've seen is people were trying to come up with ways to violate these rules before the settlement agreement was even approved. And so that's somewhat still the landscape that we're dealing with. And then we start to see now the power conferences, especially the Big Ten and the SEC, they're coming up with their template agreements. Some of them are fairly aggressive in trying to say athletes are going to assign all of their NIL rights, maybe including exclusivity provisions. That I think is intended to limit transferability of the athletes. And with respect to that transferability, some of these agreements are going to include buyouts. And if they do include buyouts, well, then we're going to see that those buyouts are going to count against that annual cap that they have to pay. So it's really just a cap constraint. It's a market constraint that's attempting to keep down the cost of labor, for lack of a better word. And then what else do we see? We still have two main unresolved issues. Title IX questions still abound, whether or not these deals are going to be judged on a Title IX standard. If they're direct university compensation, do we have that requirement of equality of opportunity? And then whether or not these athletes are employees. And so even though we now have this framework, and I think the NCAA was very happy to get this deal approved and to move on, there's still a lot of uncertainty in college sports. And I think athletic departments are really seeing this rub, and that's what they're really concerned about, because even though most people think of college athletics as this big cash cow, and the market's huge. Open Doors estimates it at 1.7 billion per year. And so you can see some of these athletes, how much they're getting paid. Athletic departments in themselves, let's see if I have this, are generally in the red. And so if they're trying to balance their budgets, and now they're looking at, for the most part, roughly a $30 million annual increase in their budget line, they're having to make some difficult decisions. And I think that's when you start to hear about sports potentially being cut. Very often it's going to be the non-revenue generating sports. And then Title IX concerns would weigh in with that as well, depending on what universities might be able to cut. And then, of course, the NCAA Division I requirements, the minimum 16 teams, all those sorts of constraints are in play. And so you start to see a lot of athletic directors starting to make some squeals about their ability to make these payments. And I guess I would say the only real benefit for them to look forward to is we now have this college football playoff that should bring in a considerable amount of money to a certain subset of schools. And I know my time is getting close here towards the end, so I just want to highlight two other things before we move forward. One, there's a reason that the NCAA hired a former governor for its president. This is right now a political question. How do we deal with college sports moving forward? And Brian's going to talk about how all the states have been trying to fill this void a little bit, because the federal government really has not yet stepped up to the plate. This summer, there are 3 bills that are currently proposed. 2 years ago, there was 5 or 6. They never really got anywhere. I would group these in 2 different buckets. We have the first 2, the College Student Athlete Protections and Opportunities Through Rights Act, or the Sports Act, and then the Student Compensation and Opportunity Through Rights and Endorsement Act. Both of these acts are fairly similar. What they are trying to do is say, we're going to give the NCAA some ability to control college sports, maybe put some limitations on transferability, on eligibility issues in terms of the number of years athletes can continue to compete, their ability to be recruited and using inducements through recruiting, and that sort of thing. So it's a little bit better for the NCAA in that sense, where they have a little bit more control, though it would still ensconce this right to name, image, and likeness rights. The bill proposed by Senator Paul, completely different. It's a 3-page proposal, but really there's just 1 paragraph of operative language. And all it says is the NCAA would not be subject to antitrust laws in the United States. That would just be a hard reset back to where we were 15 years ago, where the NCAA had more or less carte blanche to move forward. So I think I'm at my time, so I'll go ahead and pass it back to you, Mohsen.
Fascinating stuff. Thank you, Professor Weber. It certainly completely changed landscape than when I was in college. Next, we'll have Professor Derringer talk about what we've seen in terms of legislative action at the state level. Brian, why don't you go ahead?
Sure. Thank you, Mohsen. And good afternoon, everybody. I'm delighted to be here with my colleagues. And also, I'd like to give a special shout out to my Summer Sports Law Institute students who are viewing this webinar right now. So what I want to do is pick up where David left off, which is the future of NIL, the creation of the College Sports Commission, and the regulatory gap left somewhat open by the House settlement. So we know that Congress, despite our hopes, hasn't saved this landscape yet, right? And so we also know the NCAA has been busy. They've been busy with lawsuits dealing with transgender athlete rights, athlete transfer rules, the employee status of student athletes, and the infrastructure that's being built right now by the House settlement. As a consequence of the House settlement, the NCAA has relinquished, as David notes, some of their authority to the conferences here and to the College Sports Commission. Though many of the bylaws still exist, including those against pay for play, including extra benefits, including the work performed or quid pro quo requirement of an NIL deal, even if some parts of what's called the improper inducement bylaw have been enjoined by federal district courts vis-a-vis third parties. Without Congress and with a weakened NCAA, this leaves state legislatures as a source of law and a source of hope, frankly, to make what has been phrased the Wild West a little less wild. And my work and my responsibility for this session is to sort of give a very brief survey and return a report card, if you will, on what is really becoming a patchwork quilt of state law in this space. So there is, I admit, much to like about what states have done in this space. As of this spring, 34 states, including the District of Columbia, has either passed NIL laws or have executive orders on NIL. And these state laws do some great things. Broadly speaking, they permit student athletes to commercialize their NIL. They permit student athletes to obtain athlete agents for purpose of NIL. Some states like Oregon and Pennsylvania require royalty payments to student athletes whose NIL was used in things like jerseys, video games, and trading card sales. Some states permit student athletes the use of institutional marks and logos in facilities for NIL activities. And most actually ban direct payment, though these provisions will have to be amended after the House settlement. Unfortunately, however, many state laws are decidedly pro-institution first and pro-NIL and student athletes second. In one breath, some state laws promote the rights of college athletes attending their institutions, but often in the next breath, which is often a deeper breath, protect institutional rights. For example, many states prohibit NIL activity that violates a team rule or an existing university contract, which would give coaches and administrators the ability to limit the market available to student athletes. Many state laws prohibit NIL deals with rival brands to those the university contracts with. So think about Under Armour at a Nike school, or think about Coke at a Pepsi school, and things of that nature. Many state laws limit or ban the use of institutional marks, logos, facilities, and resources, despite the fact that the university has likely been making money on their student athletes NIL on those same facilities for decades, right? And unfortunately, and what I want to talk about in a quick sec, is several state laws impose content-based, speaker-based, and even viewpoint-based restrictions on NIL speech by student athletes. So as I'm going through my presentation here, my larger point is that while the NCAA is stuck in a losing streak, Congress won't act, state legislatures haven't saved the day either and are not quite blameless in this space. And it could very well be sort of some legislative blunders on the state side that finally forces Congress to act and make some uniformity. And on the screen here, I have the latest rankings by the National College Players Association of the best pro-student athlete states. So the tip here is the lighter the green, the better the state for student athletes. And so in the next few minutes, I just want to pose a question of how pro-student athlete and how pro-NIL is your state NIL law? And I want to start by talking about free speech. Because some of the state laws in the NIL space pose free speech issues. Depending on where a student athlete resides, they should be advised of these no-go zones in certain areas. In the NIL deals, they may want to encounter. And why am I speaking of speech here? Well, I'm speaking of speech because Open Doors, which I think David mentioned, which is one of the largest NIL tracking softwares or vendors in the country, they note that approximately 72 to 85% of all NIL activity occurs via social media. And it occurs via social media through influencer marketing, where student athletes leverage their social media to promote brands and products. So when we think about that, let's take a look at a couple of examples of state NIL laws to look at the language of these statutes. So let's first look at the state of Illinois, which calls out vice categories as and prohibits NIL-related speech in these categories, irrespective of whether the state criminalizes or has decriminalized the substantive matter to be talked about. So at first blush, we have prior restraints to an effect that affect at least commercial speech, if that's what a student athlete's social media influencing is pursuant to an NIL agreement. And these laws aren't viewpoint neutral because they restrict only promotion of the vice industry, not opposition to them. So they're viewpoint-based speech laws, and so ordinarily they'd be subject to strict scrutiny. I confess this is probably commercial speech, but in 2017, the Supreme Court in a case called Mattal versus Tam said that viewpoint-based speech, even on commercial speech, should be subject to heightened scrutiny. Furthermore, if you look at these categories, some of the speech has non-commercial aspects. Some of these categories, think about cannabis or sex-related products, are so hot button that they could rise to more than just commercial speech, but political speech. Like take marijuana in a state where it's legal, or a federally legal CBD substance, or think about a star quarterback at the University of Arkansas, which is up on the board, inking an NIL deal with a condom company to promote safe sex. Does that qualify as a vice category because it's a sex-oriented product? We don't know, which is another problem with these laws, and that's overbreadth and vagueness. Many of these state laws, and here I'll show the Mississippi's and Illinois that cover conduct or statements that are inconsistent with the values of the institution, or negatively impact the reputation or embarrass the institution. First, how is a student athlete supposed to know if what they're doing is covered or might embarrass their institution? And think about scenarios where, again, we move from commercial speech to political speech. Think about an athlete that has a proposed NIL-related social media post that supports defunding the police on a college campus that has taken the opposite position. Or think about a student athlete that has NIL-related speech that supports the Russian invasion of Ukraine, where the school, through the government speech doctrine, has said the opposite. In other words, speech that's not only flatly inconsistent with the university's values, but is decidedly political in nature as well. And so in addition to overbreadth, you also have the void for vagueness problem in some of these speech-related NIL laws, because you might want to ask if it gives fair notice to a student regarding what type of NIL speech is permitted, and it could also invite arbitrary and discriminatory enforcement by state or university officials. The next area that poses some concerns is what about 10 states, now counting, have done in their amendments to their existing NIL state laws. And that is dealing with the Commerce Clause and the Contracts Clause. So I want to, if you'll indulge me with a little bit of a backdrop, the NCAA's interim NIL policy was largely a hands-off mechanism that allowed sort of a Wild West to emerge in terms of the NIL space. The NCAA lacks subpoena power or other tools to require a witness to testify in an enforcement proceeding. So in the first 2 years or 2.5 years of the NIL era, very little enforcement action occurred. The NCAA mostly stood by while boosters and collectives and money flowed into this space. So what did they do? To rectify this, the NCAA did something that, I would imagine prosecutors would only dream of. It changed the evidentiary standard in NIL enforcement cases and created a guilty until proven innocent standard. States reacted to that standard, and they reacted to that standard by 10 states amending their state laws, doubling down to sort of create a wall around their state with respect to any enforcement mechanism related to NIL. They made those actions automatically violations of state law, which poses an interesting question. And so, and this doesn't really change with the creation of the College Sports Commission, because if you take their word for it, most of the enforcement is still the NCAA's. And even if you think about what they do enforce, most of these new state law amendments, I argue, would sweep in the College Sports Commission or CSC. Let's take a look at Oregon's, for example. Oregon's House Bill 4119 makes it a violation of state law for not only an association or conference, but any organization like the CSC with authority over intercollegiate sports to accept a complaint, open an investigation, or take any other adverse action against a school or a student related to an alleged violation of an NIL rule. Okay? Mississippi's amendment to their NIL law did something very similar. So what we have here is really the tale of two different leagues being created. Inside one of the 10 states with these sorts of stay away provisions, we have a state that would suffer no consequence for example, its coaches executing a pay for play scheme that entices a 5-star athlete to come to their institution. And the rest, as they say, is history, right? Compare that so that could be a state like Oregon. Compare it to a Big Ten rival, Wisconsin, where no such NIL law exists. That the same activity could be subject to an enforcement action, be it by the NCAA or the CSC or the conference or whomever, and a different result ensues. And so I've looked into whether this conflicts with the Dormant Commerce Clause. And remember, the Commerce Clause in Article 1 of the Constitution empowers Congress to act, but also bars state actions that might interfere with interstate commerce, even when Congress's power lies dormant. And so if you look at the purpose of a lot of these new state law NIL amendments, they are to benefit and insulate in-state economic interests and shift compliance burdens out of state, whoever runs that compliance regime, to out-of-state economic actors, by essentially mandating different treatment for its state schools compared to outside institutions, outside businesses, out-of-state student athletes at different institutions. Under normal Commerce Clause, Dormant Commerce Clause jurisprudence, if the purpose and design is that, strict scrutiny would apply. But even if it was if the state legislator had a facially neutral reason, the balancing test that the Supreme Court articulated in a recent case in California, coming out of California, would suggest that unless the state articulates an environmental, health, and safety reason, which none of these states have done, their state law could be subject to even the lesser test for a facially neutral law. Now, there's an exception, and you might remember the market participant exception under Commerce Clause jurisprudence. And that is that if a state moves beyond regulation and in fact participates in the market, it can't violate the Dormant Commerce Clause. And so right now, the presence of universities in the space has been that of a regulator. But with the House settlement, they become more than that. They become a buyer, potentially, a buyer of student athlete NIL. And so this gives them the argument that they fall under an exception in the Dormant Commerce Clause. And so it's something to watch moving forward. And lastly, even if there's no Commerce Clause issue, is there a Contracts Clause issue? The Contract Clause of the Constitution is premised on this idea that honoring contractual commitments serves the public interest by encouraging commerce. A formal contract isn't required for the contract clause to be implicated. And in fact, federal courts have already said the NCAA Constitution and the relationship that the NCAA has with member schools suffices. So the real question becomes whether these 10 and growing stay away state NIL law amendments substantially impair the previous contractual relationship that the NCAA has with these member institutions, which essentially creates a state law defense to performance under these contracts. And so if the whole point of the NCAA or the College Sports Commission or a conference is to ensure competition occurs at a fair and level playing field, vis-a-vis recruiting, eligibility, and rules of play, and universities join with that purpose. They don't join to be investigated, but they do have to abide by rules. I wonder if whether these state laws do more than just breach an agreement, but substantially impair the deal that was struck, decades ago when they joined the NCAA. And so these are just a few of the ways in which state NIL law make the legal landscape more difficult to navigate for businesses and student athletes, which is a topic that I know my colleague Lori will speak to as it pertains to Oregon student athletes.
Thank you, Brian. Certainly interesting to see how states have experimented and the problems with state experimentation. As Brian said, next up is Professor Lori Hauber, who will talk a bit about how Oregon law has been working to help students navigate this complex area. Go ahead, Lori. Lori, you're on mute.
Thank you. Hi, everyone. Good afternoon. Thank you for being here. Sorry, I'm going backwards with my slides. So as the segue Brian just gave, my focus is really like on that individual student athlete. You've heard kind of what's happening at the federal level, what states have done, and even as Brian mentioned, the primary focus in a lot of states is really about protecting the university rights, and not the individual student's best interest. So that's where kind of we come in. When I say we, the focus of my talk is really based on the clinic work that we have been doing in this space. And so since the fall of 2022, through our business law clinic directed by Mindy Whitcop, we have been working with individual student athletes and engaged in outreach and education across the university. And we are now, the demand for our services, and given the strong interest within the law school among our law students, we are now creating a separate NIL clinic starting in the fall. And I'll just add kind of what does that look like compared to kind of what other law schools are doing? And we really are kind of in the forefront. There are a handful of law schools around the country that do have standalone clinics in this NIL sports law and or entertainment space. And then I would say there's about a dozen or so schools that are doing this work partly through a business law or entrepreneurship clinic. And so I think being at a school like University of Oregon, I view it as important to protect our athletes because the amount of attention and interest from brands and other third parties that may not and often do not have the best interests of the student in mind. And just for many of you who took a clinic in law school or familiar with clinics, and clinics really are kind of often really centered around a social justice mission, and which begs the question, why do this work for student athletes? And what I will say is it came when Brian was in the GC's office. He is the one who came to us and asked us in the business law clinic if we would consider helping student athletes because of the kind of predatory contract deals and incredibly unfavorable terms that were making their way to the GC's office. And so that's really kind of the impetus for this. And then in doing more research to assess the feasibility, we realized despite what's in the media, average deal sizes were at most $250. And so really the idea of this clinic is to help the vast majority, 90+% of student athletes who are like kind of hustling for deals and really entering into relatively small deals, or I should say deal size. And the other thing is, we're talking about 18 to 22-year-olds, and it's unrealistic to expect students of this age to be able to understand the contract terms, what their tax liability, evaluate risk in a deal. And so our whole goal with this clinic is really to try to help students mitigate that risk. And as I said, it's all about protecting their interests. So before I say a few words about kind of the work that we're doing in the clinic and give you a few examples of what we're seeing, I just want to take a step back about kind of the kind of benefits of NIL and also just kind of the real drawbacks. And even before that, I would say there's been a long history of exploitation of student athletes. And just kind of a few points, many student athletes live or have lived below the poverty line, have experienced food insecurity, some of whom experience homelessness. And even though students receive full scholarships, those scholarships don't necessarily cover full expenses. And as you can see, this quote is kind of emblematic of the situation that many athletes confront. And then just in comparison, and as we all know, college sports have become big business. And this is a slide from David Weber. And this shows the contrast. This is the all of the states here are states. Well, I should say it's a map of the states that show who has the highest salary among all public employees. And as you can see, a preponderance of coaches. And so that's in stark contrast to what I just showed about kind of the vulnerability of student athletes. And so, and this is a longer conversation, but with that backdrop, I think the kind of recognition of this disparity is partly what got us here in the first point, and even what got us to a place where the Supreme Court ruled in favor of athletes in the Alston case. Okay, so fast forward. So what does the landscape look like since NIL has kind of become a thing and so, as David mentioned, huge market, which means opportunities for students. And again, as I mentioned, very small, medium-sized deals. But the upside is it's really opened up opportunities for students who play non-revenue generating sports. And so, but I mean, I have other data, but basically that is the gist, is that a lot of student athletes have been able to take advantage of the lifting of the prohibition against NIL earnings. And so and all of you, I'm sure, are familiar from media stories about students who are making upwards of more than $1 million outside of football and basketball. So there's examples, volleyball players, softball players, kind of a range of sports. But so then we move on to kind of individual student athlete disparities. And despite the successes, there's issues with immigration, and international students are prohibited from engaging in NIL. And I think, maybe this is a question for David, but whether or not that there's any hope in federal legislation of allowing international athletes to engage. But so the other thing to point out is that, as David mentioned, 80% of NIL money, the marketplace, is coming through collectives. So the 20% are that's the amount of money that's generated through student athlete deals with third-party brands. And that's the space in which this clinic operates. We're not working with student athletes who are making millions of dollars or even hundreds of thousands of dollars through the collective. And so again, kind of what is our clinic doing? We recognize that across the country, student athletes don't really have access to support services. And whether brands are predatory, which I think we see some of that, but I think often brands just aren't aware of the problematic contract terms they're giving students to sign. A lot of times it's not a lawyer who's involved. It's someone outside of out in business development. And so just there's a lot of misunderstanding with or lack of understanding, I should say, with contract terms. And so just what does the clinic do? This is kind of our 4 main categories. And to date, the focus has really been on the top 3. And just briefly, I guess a lot of what we've been doing is, of course, individual contract review. And kind of these are really the 3 buckets, but I would say the big one is deals with brands. And then we've seen some agent representation agreements, and then NFL draft supplemental agreements are something that we're looking at more toward the future. But so I just want to show this quote. So this is an example of something not uncommon we see with deals with brands. And you see likeness, which is name, image, likeness. Likeness is the vaguest term of the 3 in terms of what that means and how brands could take someone's image and change and potentially change it. And then, of course, indefinitely. And just to give a little perspective, this is a contract for an item under $200, like an arm sleeve. And so in exchange, see what a student is giving up, and the potential for a brand to use that student's likeness at any point in the future in a way that potentially could be harmful to the student. And then I guess so that's just an example on the brand side. And then just this is something we saw with an agent, a proposed agency agreement. And fortunately, the student who came to us said, I don't have a good feeling about this. And we were able to kind of validate the student's gut feeling. And I mean, it's ultimately up to the student, but we advise the student to not sign this. So basically, as you can see, this came to the student last fall. So this was long before there was a House settlement, but there was anticipation of a House settlement. And so already at that time, we started seeing agreements where prospectively brands wanted to take a percentage of whatever a student gained from the House settlement. And as I noted here, a 9-month survivorship clause. So obligated to continue to give that brand a percentage of their House settlement and any money the student earned from a collective for 9 months after the contract ended. And then I don't have time to go into these clauses, but just, I mean, here's a list, and this isn't even all of them, but this is just to give you an idea of just the different terms that could really be problematic for a student, and much more so than the third-party brand or the agent, given the power disparity that we normally see. And so I just want to take the last kind of minute or so and just mention highlight a couple of other things that we're doing. I show you this screen share. We've developed a separate name, image, likeness web page, and this is really not just for our law students and prospective law students, but we want this to be very user-friendly and accessible for undergraduate students. And so, like I said, it's just a quick snapshot to see kind of what we're trying to put together as resources for student athletes. And then the other thing I'd like to mention is just not only is this something that's important for student athletes, but I'm probably stating the obvious when I say this is a valuable kind of pedagogical opportunity for our students in terms of the skills that students gain in preparing for practice. And as there's more emphasis on becoming practice ready, we want to, of course, through this clinic, be able to support the educational goals and needs of our students. And then the other thing is we do a lot of teaching and interfacing with undergraduate and graduate students through the business school. They have a sports and management program. And I think that's also of value because a lot of those students are going to become agents themselves and or going into some kind of job in the sports industry. And for those people to have more awareness of the student athlete's perspective is also a kind of valuable benefit that we can add. And then I'll just say one last thing. If you are interested in getting involved at all, please reach out to me because there's certainly far more need for among student athletes than what we in the clinic alone can provide. So I will end there so we have time for questions.
Thank you, Professor Halber. And we have several questions already submitted. And if you have more, please feel free to put them in now. Well, I'll just throw some of these out to the panel and anyone can feel free to respond. One question concerns about the new framework contemplated by the House settlement and NIL deals generally, how they might affect the transfer market for student athletes. Do we expect to see anything about the House settlement or NIL deals as they're inked in practice affect the transfer market and how the ability of student athletes to transfer among schools?
Yeah, I'll jump in first, and anyone else can jump in too. This is probably my favorite topic right now in college sports because we're seeing so much tampering with athletes that are currently on rosters where a university is trying to poach them. And we just have our first lawsuit filed. University of Wisconsin filed a lawsuit against Miami, and it's essentially a tortious interference of contract claim where they said you poached our athlete who was under contract with us for NIL. You can't do that. So that's one way to certainly try to pursue it. The other way is I think we're going to see these buyout clauses put into the NIL agreements. So if another university wants to do that buyout, well, they can go ahead and do that. They can pay the departing university that amount of money, and that will count against their cap. So if that counts against their cap space, that limits who else they can sign. And so it's just an external constraint in terms of trying to limit that maneuvering of athletes. And I think both of the federal proposals were really concerned with the transfer portal. I think there was a fair amount of negative publicity this year with athletes who had to sign into the portal before their school season had even ended. And I think people thought, well, that's not a great look for college sports. And it wasn't the athlete's fault. It was when the portal was open. So if they were going to transfer or test the waters, they had to do it that way. So whether or not federal legislation is a realistic opportunity or hope at this point in time, I'm not so sure. But I do think we'll see more of these financial tools being used and contract tools to try to limit some of that third-party transferring.
And I will just add, we haven't talked about student athletes as employees. Of course, we could have a webinar devoted just to that. But another way, whether it's a buyout clause or a limitation, would be through a CBA process, where if there was a collective bargaining agreement, then the terms of that agreement could mete out what happens if and when a student athlete would like to transfer or does transfer.
Another question deals with just, are there any regulations or anything in the House settlement that would limit how much an individual athlete could receive either from a school or a collective? And just to step back, there's also a question of what do we mean by a collective for those of you who might be unfamiliar? Can someone answer just generally, what do we mean by a collective? And then the question deals with, are there limits on how much an individual athlete can receive from a school or a collective, either under state rules or under the House settlement?
I'm happy to take the first question of what is a collective. Basically, the collectives are independent entities, oftentimes formed by boosters, so set that aside, that raise capital and distribute that money to student athletes for their NIL, but do a host of other activities, including reaching out and soliciting third-party businesses, connecting them with the student athlete, perhaps negotiating an NIL deal with that third party, and essentially offering services so that student athletes can get paid for their NIL. And they popped up for various reasons, but a collective is not the institution. And so that was sort of a Band-Aid process that would alleviate the institution doing this because they were prohibited by state law and other restrictions might apply.
And I'll hop in on that second part of that question with the limits on what can be paid. So under the House settlement, the direct compensation from universities this year will be capped around 20.5 million. And so, and that's across
student
all
athletes?
sports, for all student athletes.
Oh,
So
for all.
that's at each university. So if a university has 500 athletes, they divvy that up accordingly. Now it's estimated that 70% of that will go to the football team. So you're looking at roughly 14 million and change across roughly 105 roster spots. And so you can see quickly that if you're paying $1 million, that amount won't go very far. So those are the kind of the constraints on that side. On the collective side, I'm sure everyone has heard the phrase wild, wild west in terms of the NIL space. I have consulted with a fair number of collectives. And this year, prior to the House settlement being approved, all of them were trying to get their deals inked before they would have to submit them to this NIL Go clearinghouse for approval. Because I think there was a fair understanding that most of these deals aren't sort of commensurate with what a known brand would pay for advertising in this space. And so right now, the constraint is going to be, can these deals pass muster under Deloitte's new tool that they're going to look at? And so what I think you're going to see is either the deal values are going to come down in size in terms of the monetary value, or we're going to really see an increase in the deliverables that the athletes need to provide in order to make that valuable. And I wouldn't be surprised at all to see more of these moves where collectives merge or work with existing brands to try to disguise some of those payments in a way that they are for goods and services so that they might pass muster under that new test. But other than that, there's no cap or ceiling on what's permitted other than now this fair market value standard.
Thank you for that. I think we have time for one or two more, perhaps. A question about what role, if any, do agents play in negotiating NIL deals for student athletes? I know we see agents commonly in professional athletics. Are agents are there agents involved in negotiating and helping student athletes navigate NIL deals?
I mean, I can take it on kind of the smaller end. Most certainly, yes. I mean, that's kind of one of the category of agreements we see are these deals where agents offer to students that they will bring in the NIL opportunities with third-party brands. I mean, I see anywhere between 15 to 30% of then the revenue that's the agent's cut for bringing in these deals. I think one of the challenges is that it's awfully mushy what these agents say they will bring in. Yet, as I showed on the screen, often agents are finding a way to kind of get a cut of students' earnings, whether it's specific to the deals in the contract terms or not.
So there's also a question about taxes, which is something that I love to think about. Are schools charged for with withholding taxes on payments to be made to student athletes, or are student athletes going to be expected to navigate the tax consequences for themselves?
So, well, I can answer out of all the students we've worked with directly and in our education sessions, never once have we had a student who's understood that what they earn is taxable income.
Oh boy.
Literally out of hundreds. And so this is a huge, huge concern. And so the only way that student athletes have money withheld is if they are entering into a deal through the Open Doors platform, which Brian and David both spoke about. And the Open Doors will handle that piece of it. But no one's helping student athletes file their taxes or even helping student athletes understand the process. And so this really this is an area that I think somehow has got to be addressed. I don't know,
Well,
David or Brian, if you have anything to add to
well,
that.
we're unfortunately we're at time, so let me finish by we could of course go on for another hour on these topics, but let me finish by thanking Professors Weber, Derringer, and Haber for sharing their expertise on NIL deals and the landscape and leading us through this fascinating discussion. And thank you to everyone for tuning in. We hope you'll be able to join us for our next two webinars in this summer series, which will be held on August 8th and August 14th. On August 8th, Professor Howie Arnett and Chuck Sams, who is the incoming Oregon Tribe Scholar in Residence and Senior Fellow with Oregon Law's Native Environmental Sovereignty Project, will explore Indian law and Native sovereignty and discuss trust and treaty responsibilities for public lands. And on August 14th, Professor Angela Ade will discuss her research in racialized burdens and the power of rulemaking, unraveling discriminatory liquor license enforcement. I hope to see both of you at both of those events. Thank you again for joining us and have a great rest of your day and weekend.